Well, good afternoon and welcome to the Scaringi Law Lunch Break. This is your time of the day to learn a little bit about the law while you enjoy your lunch. In the case called Barr v. American Association of Political Consultants, Inc., the United States Supreme Court recently upheld the constitutionality of the Telephone Consumer Protection Act of 1991, known as the TCPA, which generally prohibits robocalls to cell phones. It found that one amendment to the TCPA to be in violation of the First Amendment, and as such severed that amendment and held just that amendment to be unconstitutional and permitted the remainder of the TCPA to stand. Thus, robocalls to cell phones still violate the TCPA. Now, who sued whom? Well, the American Association of Political Consultants sued the federal government, claiming that the TCPA violates the First Amendment to the United States Constitution's guarantee of free speech. Well, what is the law on free speech? Ratified in 1791, the First Amendment provides that Congress shall make no law abridging the freedom of speech. The United States Supreme Court held in 1972 that above all else, the First Amendment means that government generally has no power to restrict expression because of its message, its ideas, its subject matter, or its content. The court's precedents allow the government to constitutionally impose reasonable time, place, and manner regulations on speech, but the precedents restrict the government from discriminating in the regulation of expression on the basis of the content of that expression. And that's the key word, the content of that expression. Now, lastly, the court has held that content-based laws are subject to strict scrutiny, meaning content-based laws on speech are only permitted if they satisfy a compelling state interest. So, in this case, the plaintiff was trying to get the entire TCPA struck down as unconstitutional so that their members or political consultants who handle and run campaigns for political candidates, so their members could legally conduct robocall campaigns to the cell phones of potential voters. So they zeroed in on a 2005 amendment to the TCPA, which exempted robocalls made for the purpose of collecting government-owed or guaranteed debt, including robocalls made to collect many student loans and mortgage debts. So the plaintiff claimed that that exemption for the collection of government debt was not content neutral, and it favored the government, but yet prohibited all other robocalls, and as such violates the First Amendment rights of the plaintiff and any political consulting group that wants to conduct robocalls based upon political advocacy. And as such, the entire TCPA should be declared unconstitutional. Now, that was a very clever argument raised by this Association of Political Consulting Firms. Now, but if the court agreed and declared the TCPA unconstitutional, then the plaintiff and all other individuals and groups could make robocalls to your cell phones. So remember, laws cannot restrict speech based upon content. They must be content neutral to pass constitutional muster. In this case, the plaintiff pointed out that their speech that discusses candidates and issues, solicits donations, and conducts polls and gets out the vote, is prohibited to be conducted via robocalls because of the TCPA. But the government speech, requests, demands, encouragements of debtors to pay their government-owed debts, well, that is permitted to be conducted via robocalls per the TCPA, and thus that law discriminates based upon the content of the speech. And they were correct. The United States Supreme Court, in an opinion written by Justice Kavanaugh, agreed with the plaintiff. The court held, because the law favors speech made for collecting government debt because it allows it via robocalls, over political and other speech because it disallows it via robocalls, the law is a content-based restriction on speech. Now, remember, the plaintiff asked the court to strike down the entire robocall ban from the TCPA. But the court said, no, we're not going to do that, because that would defeat the purpose of the law, which is to protect consumers from being harassed by robocalls on their cell phones. And as such, the court simply severed the offending 2005 amendment, which had unconstitutionally carved out an exception from the robocall ban for government debt. Thus, the government can no longer conduct its debt collection efforts via robocalls to cell phones, and we Americans continue to be protected by the overall robocall ban set forth in the Telephone Consumer Protection Act of 1991. Well, that's all the time we have today for the Scaringi Law Lunch Break. I hope you learned a little bit about the law. Thanks for listening, and enjoy your lunch.